So, Paul, the consolidated directions on occupational health and safety measures, and these comes under the Disaster Management Act of 2002.
Yeah.
Are these actually law?
Yeah. Well, they are law. It's legislation, it's a statute, it's law. I think the real question is it law that is, that should be out there? Because when we talk about law has to be aligned. And so the Constitution that we have, Constitution of South Africa, is our most supreme law. And all other pieces of legislation must take their strength from the Constitution and must not be out of alignment with the Constitution. So the question is, are these laws in alignment with the Constitution? Because that is the real thing. And that is what the courts really need to decide upon.
But these are the regulations that most employers have used to institute mandatory vaccinations. Now,
Yeah.
When these sort of regulations, do they then say anything about whether dismissals can happen or not?
Here's the thing about the regulations, which I also put to the Deputy Minister of Health, because we had a Zoom meeting with Dr. Dlomo, and he said to me in that Zoom meeting that government has never said vaccination is mandatory. And I said, well, you need to make that clear, because even the employers are under the impression that government has taken a mandatory vaccination stance. Now, the regulations do not say make vaccination mandatory. What they say, they impose on the employers an obligation to do a risk assessment and then to put in a policy in their workplace. So they give them a license and a discretion to do that. But what they're just saying is make a plan to manage COVID. So that plan does not need to include vaccination. The plan is open to social distancing and wearing masks. So but unfortunately, the government has not come out to actually say that vaccination is not mandatory. In fact, in some instances, some of the ministers are making it look like it is mandatory. Like, we had a sports match, I think, not too long ago, and people were told you can't go into the stadium unless you're vaccinated. That's imposition of mandatory vaccination. But the government is saying it's not our policy as yet.
So simply put, an employer can't just dismiss someone because they're vaccinated. They're not vaccinated.
As far as I'm concerned, they cannot. They cannot. I mean, we have so many labor laws that are there, and I'm just fortunate to have been part of an office. The ILO Swiss project was an office I worked with in 2000, and that was the office that really facilitated the establishment of the CCMA and also helped with the labor law regulations, the drafting of the labor laws with, I worked with Charles Nupin, and Professor Halton Cheadle is the one who helped us with those labor laws, the drafting of those labor laws. So there are 5 labor laws, main acts. You've got the Labor Relations Act, you've got the Skills Development Act, you've got the BCEA, Basic Conditions of Employment Act, you've got the OSHA, Occupational Health and Safety Act, and you've got the Employment Equity Act. So those are the 5 main acts that are out there for labor law. So in terms of that legislation, it's there to protect employees from dismissal. And it's one of the reasons why I wrote an open letter to COSATU recently, challenging them for their stance to try and validate mandatory vaccinations. I said, COSATU, that is not your assignment. Your assignment is to prevent employees from being dismissed and to make sure that labor legislation, which was put there and which COSATU had an input in, to make sure that they're not arbitrarily dismissed. In South Africa, with a more than 40% unemployment rate, it's reprehensible that people will be dismissed when at the end of the day, vaccinated people can contract and transmit COVID. It's scientifically proven that they can, just as well as unvaccinated. So if you're going to dismiss unvaccinated employees because they can contract and transmit COVID, then you need to dismiss equally those who are vaccinated in terms of equity and non-discrimination.
What then are the obligations of the employer then in these cases? Where do they go? Because it seems like they're between a rock and a hard place.
The employers. Well, the employers were told under the regulations to make a plan, and so that's their obligation, is to make a plan, and that plan must not be a discriminatory plan. It must be a plan. I mean, as South Africans here, we know about discrimination. We fought hard against apartheid. So we don't need to open the road for a vaccination apartheid. Last night I was on a Zoom meeting with the student representative, SRC representatives of various universities. And the students told us terrible tales of how they were being discriminated against. Separate entrances, being denied access. You're not allowed to do entertainment. You're not allowed to, but the vaccinated student can equally transmit it. And that's the reason why vaccinated people still have to wear masks. That's the reason why vaccinated people still have to social distance if they couldn't contract it. And we know of even some of our leaders in South Africa who were fully jabbed, but they contracted COVID. You know, I won't mention names, but we know. So it's discriminatory then. If we both can contract and transmit it, then it is a clear case of discrimination. And it's not the testimony that we want to carry in South Africa. We who fought so hard against discrimination, and university students who just want their right to education, access to education, and are treated in this manner. It's just completely unacceptable.
But we've seen employers retrenching people as far back as 2021.
Yeah.
Especially towards the end of it. Some of the employees then took the employees to the CCMA for unfair dismissal.
Yeah.
And in the last 2 weeks or so, we've seen a CCMA case where the results were actually in favor of the employers.
Yeah.
Do you think that these rulings are fair and right?
Absolutely not. I've done recordings and I've also done, write-ups on that. So there's two cases actually. There's the Teresa Malderay case and there's the Gideon Koch case. And in both cases, the CCMA commissioners ruled that the dismissal was fair, which in my view was completely flawed rulings. I wrote and I presented the reasons why. I first of all want to say that CCMA, it's the courts that set precedent. The courts set a legal precedent. CCMA is a commission. It's not a court. So I want to address that first and foremost so that people don't think that they really have set a precedent. And as far as I know, one of the rulings has been taken up already on review, if not both. Now, when you take a case up on review, it simply means that the application of law, the legal application the commissioner erred in his application of law. I think one of the problems I see with the Teresa Malderay case is that she represented herself. And I think it was a mistake on her part because the issues that should have been presented are constitutional issues. Section 12, which everybody has cited, 12(2)(c), which talks about the right to bodily integrity and the right to physiological integrity, that every person has that right. It's constitutionally entrenched. And we take it also from international legal instruments. For instance, like the Nuremberg Code, Article 1 says exactly that. It says you have a right of bodily and physiological integrity. It also talks about the issue of informed consent.
Yes.
So informed consent means before somebody puts any medical intervention in you, Mac, they're supposed to advise you and tell you what is in there, what is in the content of that vaccine. Section 10 again of the Constitution, it says you have a right to dignity. And the courts have interpreted right to dignity as meaning that you have freedom of choice. They say right to dignity and freedom of choice, they go hand in hand. They're inextricably intertwined. They're like twins. They can't be separated. So if I have a right to dignity, I also have a freedom of choice. Where is the freedom of choice in this instance, where I'm forced to vaccinate?
That's true. So we've seen, with these consolidated directions, a lot have changed. We've got a new variant that has now emerged, regarding the directions of 2021. Now, should things be changed, or does this change things? Because the variant keeps, changing the whole time.
The variant keeps changing, and it's changing. The same vaccination that is being made mandatory is not dealing with some of these variants. So why are you going to make something mandatory? I mean, the vaccination couldn't deal with Omicron. And your natural immunity, and doctors all around the world are saying this. I belong to a group called World Council of Health as a legal spokesperson. And they're saying that your natural immunity actually works better for you. And I believe that we as South Africans have actually validated that. You know why, Mac? Because on January the 31st, from the Office of the Presidency, a notice was released to say, we are relaxing some of the COVID protocols. And why are we relaxing them? There were some reasons that were advanced. First of all, in the relaxation, they said, on alert level 1, we are now saying that if you test positive for COVID-19 and are asymptomatic, in other words, you have no symptoms, show no symptoms, then you need not isolate. Second thing they said is if you test positive for COVID-19 and you do show symptoms, you no longer need to quarantine for 10 days. It's reduced to 7 days. Third thing they said in that is that learners at school no longer need to socially distance. That requirement of 1 meter social distance was removed. And this is what now the Office of the Presidency said, the reason why. They said because with the seroprevalence, I'm not a medical doctor, I'm just a lawyer, but the seroprevalence, which means there was a scientific study done, the studies show that South Africans have reached between 60 to 80% immunity. 60 to 80%. Now, when you average that out, that's 70%. When you use the median mark. Yes. And guess what? 70% is also the figure for herd immunity. So they're saying that South Africa has reached herd immunity. So why, if we've reached herd immunity, United Kingdom has not reached herd immunity, but Prime Minister Boris Johnson saw it fit to actually remove the COVID protocols. There's no longer a requirement to wear masks in the United Kingdom. There's no longer a requirement to social distance. In fact, he announced, I think yesterday, that by the end of the month, every single COVID protocol will be, removed.
Yes, abolished, yeah.
Will be abolished. And this is a nation that has much higher COVID statistics than we have. So if we have reached herd immunity, and by the way, only 30% or so of South Africans have been vaccinated. So it means if we have close to 80% immunity, that now, I mean, I'm not a scientist, but it tells us that the bulk of that is natural immunity. So if it's 80% immunity we've reached, and only 30% have been vaccinated, we're looking at about 50% we've reached herd immunity with natural immunity. We as South Africans should be shouting that message out. As Africans who have a maximum of only 11% vaccinated in Africa, but we have the lowest COVID figures. We should be the poster child to show how it's done. Not countries and nations in Europe and UK, where there are nations that people have been 190% jabbed. And some of them are on their 4th booster, and they are the most hospitalized nation. So we should be the poster child to say, come see how it's done here. So I think as the government, our businesses, come on South Africa, our businesses, our economy has gone to nothing. Our businesses have suffered. It's bringing in discrimination. It's bringing in division and strife in our nation. It's causing lots of emotional havoc. It's splitting up families. And we're appealing to our nation right now. Just do away with the protocols. Let's get back to our lives. We've reached the herd immunity, which you've been saying you wanted. That was the reason, Mac, they pushed the vaccination, so that we could reach the 70% immunity. Now you've announced that we've reached it. So, and now? Hebatung. Ariyeng South Africa, let's go.
It's time to move.
Genako.
Something very interesting here is that, in these two rulings that were made, we've got the Mulderidge case, that's the first one, and then we've also got the case of Cockpit. I just want you, very quickly for me to, just encapsulate in a few sentences.
Yeah.
In the case of Mulderidge, what is a defense? Mulderey,
Yeah,
okay.
Mulderey.
In the case of Mulderey, what was her defense and what did the CCMA find? And are you satisfied that the CCMA made the right decision?
Yeah. In the Mulderey case, she brought up a number of issues. She talked about the aspect of, her bodily integrity was some, and her constitutional rights were some of the reasons that she advanced in her support. I think the mistake was not bringing up the aspect of discrimination as well, because like I've said, discrimination is a very important thing. Now, the Employment Equity Act prohibits unfair discrimination. Why am I emphasizing unfair? Because there's something called fair discrimination. So, and we in South Africa know around affirmative action policies, those kind of policies are seen as fair discrimination because it's trying to address redress the imbalances of the historical imbalances of the past. So that would be looked as fair discrimination. But so unfair discrimination should have been raised. And to say that, look, both myself and the vaccinated employee can contract and transmit the virus. So why am I being fired or being disciplined? Because if that's the case, we should all be fired and we should all be disciplined. So there's some important arguments, I think, that she didn't raise. And what is concerning about the ruling, in my view, is that the commissioner in that case ruled that and found that she had permanent incapacity because she was not vaccinated. I don't see how, first of all, there was no medical evidence that was brought in to show she had permanent incapacity. Nothing could substantiate that. When you look at the schedules and the Code of Good Practices, I think it's Schedule 8, that talks about and defines incapacity. It really defines it on 2 or 3 levels. One of the levels it speaks to is you may be seen to have incapacity for poor work performance.
Yes.
Where you're just not up to standard, you're not doing your job, you're not up to scratch. So there's an incapacity that relates to poor work performance. Then there's an incapacity that relates to sickness. You've been sick for so long. None of those instances applied. Teresa was not charged with not being able to do her work. She was not sick in any instance. So I really fail to understand how the commissioner could have applied. And he said permanent incapacity. So if you're not vaccinated with COVID-19, how does that make you permanently incapacitated? Permanently incapacitated. COVID-19 has been said to be 98% of people recover from COVID to begin with. How can you talk about permanent incapacitation in that the incapacitation should be dealt with on the basis of, are you able to do your job? That should be the basis for determining incapacity. That should be the question. Are you able to do your job? Are you able to fulfill the what we call inherent requirements of your job? Yes. Are you able to sign in? Are you able to do whatever, apply your mental capacity and physical capacity that it takes? If yes, then you should be allowed to do your job. And there's a principle that the employer must do everything reasonably possible to avoid dismissing employees because we have such a high unemployment rate. It was 40% before. Now with lockdown, I don't even know what the employment rate is. So that was one of the issues with regard to the Teresa Mulderey case. The concern I had with the Gideon Gok case is with the Gideon Gok case, the commissioner again made a huge blunder in my view, in my perspective. When he alluded to the fact that Gideon had contracted COVID, and he said that there were other employees in the workplace who contracted COVID. And he said, in all probability, it was Gideon who actually spread the COVID. I have a problem with that because, like I've said, vaccinated employees also can contract and transmit COVID. So with no scientific evidence and with no medical evidence brought in to show how the COVID was spread in the workplace, I think it was extremely erroneous to make a finding that it was Gideon who brought the COVID in, because equally a vaccinated employee could have actually brought that and transmitted the COVID.
But it also seems like the legal fraternity is divided about these cases, and none of the legal principles have been used or tested in a court of law, number one.
Yeah.
And Are there any pending law cases or similar law cases that are dealing with this issue as well?
Yeah, and in fact, as soon as after this interview, I'm going straight to Bloemfontein. I'm driving to Bloemfontein because there's a very important case. Like I've said, the CCMA rulings are there. In my view, they're flawed. They're going to be taken up on review. But this court case is of extreme importance because, like I've said, court cases do set precedent.
Yes.
And so this case in Bloemfontein is a case involving Free State for Choice. It's a movement called Free State for Choice. And I've been working with, who's now become a friend of mine because we've been so involved in this case with the chairperson of Free State for Choice is Dr. Willie Shaw. And this movement is taking UFS, University of Free State, to court for their policy on mandatory vaccination.
Yes.
So this is the case that I'm going for, and we're hoping it will set precedent. And we're not going to stop. I mean, if whatever happens, Constitutional Court would have to be the final say, because this case is not about mandatory vaccination, Mac. This is about constitutional rights. And so the fight is for constitutional rights. They are hard-earned, hard-fought-for rights. Your freedom of association, freedom of movement, freedom of speech, freedom of religion, belief, and opinion. Those are constitutionally entrenched rights. Your right to choose, freedom to choose, and right to decide what goes into your body. Those are constitutional freedoms. And this is what the fight is about. It's not really about vaccination. It's about making sure that those rights are not violated, because if they're violated now, it's going to set a precedent for their violation in the future.
Speaking about precedents, now when you look at June 2021, government made provisions for mandatory vaccinations and issued some guidelines that need to be followed, when an employee refuses to be vaccinated. I'm going to read them to you quickly. Employees must be informed of the right to refuse vaccination based on the constitutional and medical grounds, as you've mentioned.
Yes.
The constitutional grounds are the right to bodily integrity, the right to freedom of religion, belief, and opinion, and this is in section 13 of those guidelines.
Yeah.
That the employer must take responsible and reasonable steps to accommodate the employee.
Absolutely.
Now, these newly published guidelines, do they constitute legislation, number one? And number two, are they binding in any way?
Regulations, when you have regulations, the purpose of those regulations is to explain the how to the statute. So the law is actually the statute. Mm-hmm. And the regulations, because you can't put everything in a law, so the regulations are just showing how to implement the law. So from that perspective, they are binding. They're legally enforceable because they accompany the statute. And the main statute is what carries the force of law. So those regulations, because I've been seeing people sending out little SMSs, this is not law, they're not, so it's a little bit misleading to say that, because the regulations they're legally enforceable because they're connected to the Disaster Management Act, which is actually law. But we're actually saying that law is out of alignment with the Constitution. And whenever you have a statute that is not aligned with the heart and the DNA of a constitution, that piece of legislation must be amended. It must be fixed. Because it must, like I say, it takes its power and strength from the Constitution. And above all, the Constitution, those rights must be defended with everything that you have. I've heard people talking about the limitations clause, Section 36. No, but Section 36 allows you to limit those rights. Listen, those rights are such serious rights. They cannot willy-nilly be thrown away. You have to fight to protect them. And so you cannot easily dismiss any of those rights on frivolous and vexatious claims. So in the aspect of vaccination, when you have alternatives that can be used to deal with COVID-19, I would say that those are not grounds to remove somebody's rights. You can't apply Section 36 when there are alternatives. There's social distancing alternatives. There's so-called mask alternatives. There are other medical interventions.
One last question. None of these cases have been tested in a court of law. Now, with that being said, then should employers rather not then refrain from acting until there is clarity from the Constitutional Court?
I 100% agree with you. 100%. We have so many cases. Last night, the word that was used by the SRC representatives was the word coercion. They said coercion. They say they're telling us that it's a choice, but then they're saying we can't register unless we're vaccinated. So it is a form of coercion. It is coercion, and we cannot allow this. To coerce people into something that they do not want is to move from a democracy to become a dictatorial state, to become an authoritarian state, to become a totalitarian state. And that's not who we are. We are the Republic of South Africa, which comes with certain democratic ideals, majority rule, rule by the people, which means we consult. In this instance, there's been no consultation.